Case number 110549, State v. Monclaw.
May it please the court, my name is Carl Maughan. I represent the appellant, David Monclaw. Your Honor, I'd like to reserve 4 minutes for rebuttal, please.
4 minutes is granted.
Thank you. I'm not going to belabor the issue of whether or not the appointment of counsel and a hearing is required under the plain meaning of the statute. I recognize the court's previous decisions on that, and I just have briefed it to preserve the issue and ask the court to reconsider it. I would like to focus instead on whether in this case the court abused its discretion in denying the defendant a hearing based on whether or not substantial issues of fact and law had actually been raised in the defendant's motion. The question for the district court at the time that it summarily dismissed the defendant's motion was not whether or not the defendant would win on the issues he raised in his motion, but whether or not the defendant had raised substantial issues of fact or law, and whether or not he then deserved a hearing on those issues. And I would suggest to the court that in this case the answer is yes, especially when we follow the liberal construction of pro se motions rule, and we look at the defendant's motion and we note that he has raised issues regarding whether or not the trial court conducted a proper weighing of the aggravating and mitigating factors as required by statute before imposing a hard 40 sentence. Whether or not that hard 40 sentence and those aggravating factors should have been considered by a jury, and whether or not the defendant's presence was required to be present at the time of the restitution hearing, or the order of restitution in this case. These are all issues that have a factual basis and also are supported by legal precedent, as I've cited in my brief. With regard to the issue of whether or not the trial court properly weighed the aggravating and mitigating factors, trial court concluded that because the victim had been killed by 22 blows to the head with a claw hammer, therefore the death was committed in a heinous, atrocious, and cruel manner. However, there wasn't ever any factual finding as to when the victim actually died, whether the victim actually died from the first blow of the hammer or the 22nd blow of the hammer, or whether the defendant or the victim lost consciousness after the first blow of the hammer. So the question, and in previous rulings, this court has noted that if the victim is already dead, and I've cited to these cases in my record, that what happens after that cannot be considered to be an aggravating factor as far as being cruel and heinous, and or whether or not the victim was in fear for their life. And I'd ask the court to apply that same rationale here and find that the district court failed to conduct a proper weighing of the aggravating and mitigating factors, because the state's coroner testified that she did not know when the victim had died. And as such, there was no factual basis to find that this, in fact, was committed in a heinous, atrocious, or cruel manner, as it's very likely that, or quite possible, that the victim died after the first blow of the hammer.
And so you're saying that it has to be multiple blows to be heinous, atrocious, and cruel?
No, not necessarily, but that was the finding of the district court, and that was why the district court imposed the...
But my question is, even with one blow from a claw hammer, a court could, subject to an abuse of discretion, find that the evidence established that particular factor, could it not?
A court could if it put out the factual basis.
And so why does that deprive the court of jurisdiction? Why does that make the sentence illegal? You're attacking the sufficiency of the evidence rather than the imposition of that particular sentence.
The reason why the sentence is illegal is because the court failed to do an actual weighing of the factors. It simply made a conclusory statement, this was done in a heinous manner because of this, this, and this. But it did not weigh...
But that's a process argument. And typically on our illegal sentences, we've said, well, the sentence didn't conform to statutory provisions regarding method and length of service, rather than the process to get to that.
That is
the
true.
question. So the question is a challenge to the process of sentencing a subject amenable to a motion to correct an illegal sentence?
I would argue it is when the process is laid out by statute, and in order to impose the sentence, the court must follow the statute and make these findings. And so when the court doesn't follow the statute by process, the sentence it imposes is contrary to the statute of, in order to impose a hard 40 sentence, the aggravating factors must outweigh the mitigating factors. And so I would argue that in this case, yes, indeed. But even if the court finds that that does not make this sentence subject to a motion for correction of a legal sentence, the question of whether or not, and again, Your Honor may point out this is a process issue, but whether or not the hard 40 factors should have been found by a jury as opposed to a judge. That would also be a process, but it would deny the court of jurisdiction to impose the sentence if the defendant's right to jury trial was in fact violated in that case.
But that's a due process violation, isn't it? If the judge makes a determination that should be jury
I would argue it's a denial of fundamental rights.
or Sixth Amendment, but the point is going to be the same either way. Those are subject to waiver; they're not jurisdictional. If the defendant's Sixth Amendment right to jury trial or Fifth Amendment right to due process are violated, that's not a jurisdictional problem. That's a error problem.
I would argue that any time the court imposes a sentence in violation of the Constitution, it ought to be considered a jurisdictional issue. A constitutional order from a court is void at its initiation. And so if the court is issuing void sentences because they do not follow the Constitution, then it should be considered without jurisdiction and therefore illegal.
Well, the trouble is if it's void, then it's subject to attack at any time. And so then that would mean that we've been misapplying the 1-year limitation on 1507s, because if the sentence was void, it's subject to attack at any time.
Well, and that's correct. As the statute on motion to correct illegal sentences applies, a legal sentence can be corrected at any time. And I would suggest that while the 1507 1-year statute of limitations, I understand the argument there, but that there is a exception to that when you can show that there was manifest injustice, as would be the case when somebody imposed a sentence in violation of the Constitution. And I understand that the jury trial argument of a lien, lien came out well after this case was argued. I understand that, but I would suggest to the court that this sentence was never actually final, because the restitution that was ordered was not ordered in the presence of the defendant, and the defendant, and as such, and because restitution is part of the sentencing has never actually been completed yet. The restitution argument or imposition was done in violation of the statute, and at the very least, this defendant is entitled to a hearing on the motion to correct a legal sentence on the restitution side of things, because the amount of restitution was ordered without the defendant present, as is required by statute. So the sentence was imposed without following the statute. And again, I would just assume Justice Johnson would say, well, this is a process issue, not necessarily the length of sentence. But when we're determining the amount of restitution, it is part of the sentence. And I would suggest to the court that when the defendant is not present as required by statute, the imposition of that restitution is illegal. And I would ask the court to either remand this case back to the district court for a hearing on the defendant's motion, or vacate the defendant's sentence and remand for resentencing based on the illegality of the sentence. If the court has any other questions.
Any more questions? Thank you, counsel.
Thank you, Your Honor.
May it please the court and counsel, Assistant District Attorney Matt Maloney for the state. With respect to the motion to correct an illegal sentence argument, this court has consistently over the years indicated that that statute and that term, motion to correct an illegal sentence, have a very narrow meaning. And as Your Honor indicated, it is when a sentence is either imposed by a court without jurisdiction, when a sentence does not conform to the statutory terms, or when the statute is ambiguous with respect to the time and manner in which it's to be served. The first argument that the defendant's raising has to do with whether the court properly weighed the aggravating and mitigating circumstances. And as Justice Johnson indicated, that's really nothing more than a sufficiency of the evidence type of argument. That's something that does not fit within any of those three criterion, and it's something that not only does it not fit within the definition of a legal sentence, it's something that could and should have been raised on direct appeal. And the case law is also consistent in telling us that issues that could or should have been raised on direct appeal are deemed waived or abandoned if they are not. The defendant's direct appeal is essentially rendered meaningless if he can then 20-some years or close to 20 years after the fact come back and make an argument and simply say that he doesn't like the result that the court reached in imposing the sentence. Likewise, turning to the Alene argument, this court's case law has also been consistently clear that a claim that a sentence is unconstitutional is not properly raised in a motion to correct an illegal sentence. Alene is a constitutional-based decision. It's a Sixth Amendment right to a jury trial decision. That's what formed the basis for the Alene opinion. And therefore, a claim that the court failed, that the sentence violated Alene, is also an issue that cannot be raised in a motion to correct an illegal sentence. There simply is no argument that the court didn't have jurisdiction, or that the sentence didn't conform to statute, or that the sentence was in some way ambiguous. So this is a claim that simply cannot be presented in a motion to correct an illegal sentence. Counsel's correct that a motion to correct an illegal sentence can be raised at any time, but that does not eliminate the requirement that an illegal sentence claim actually claim that the sentence is illegal, as that term has been consistently interpreted by this court. I'd also note that, I think counsel acknowledges implicitly in both his brief and his argument today that Alene does not apply retroactively. I don't see anywhere in which he's argued that Alene applies retroactively to cases that are on collateral review. He's simply trying to argue that his case is not on collateral review because it's not final. And again, my first response to that would be, you don't even have to get to that line of analysis because his claim itself about Alene does not fit within an illegal sentence claim. The second part of my response to that would be with respect to the restitution issue. Frierson and Hall indicate that before those cases were decided, the process did not require any magic words, that it was kind of done informally, and that had always been accepted up to that point. and those opinions indicate that the new standard, the new process applies from the date of those opinions forward. So I would argue that in evaluating whether the restitution was properly handled in this case, this court should evaluate that under the pre-Frierson and Hall standard. And I would submit that this case is incredibly similar to what happened in Frierson itself. And therefore, under that standard, it was appropriate. The court did indicate that it was going to impose restitution. It was simply a matter of the final dollar figure that was still up in the air. The court expressed its willingness to hold an evidentiary hearing on that if the parties did not agree and could not come up with the final number. Obviously, the defendant never ended up requesting that type of a hearing. Everything was signed off on and was finalized. That was appropriate under the procedure that was in place at the time. And I would argue that even under Frierson, even if you're looking at the new standard, that would, like Frierson, be the functional equivalent to a continued bifurcated hearing. So for a number of reasons, our position is that none of the claims that the defendant is making in his motion fit within the definition of a legal sentence, and therefore the motion could properly be denied without appointing counsel or conducting a hearing because there were no substantial issues presented. It is our request that the decision of the district court denying defendant relief be affirmed.
Any more questions? Thank you, counsel.
Thank you.
Your Honors, I think it is clear that in order for a motion to correct a legal sentence to be brought, the sentence must either be imposed without jurisdiction of the court or be contrary to the statutory interpretation. Judge, I would argue here the state kind of tries to lay this out as the hard 40 issue is simply a sufficiency of the evidence argument. But I would argue that it is not, in the sense that without the aggravating factors outweighing the mitigating factors, any sentence imposed, any hard 40 sentence imposed, is not imposed within the context of the statute that allows for a hard 40 sentence. And therefore, the hard 40 itself is in violation of the statute.
So you're saying it's an issue of law, that the weighing was so insufficient that there was actually a legal violation, not just a sufficiency issue?
Correct. Basically, Justice Beyer, the district court failed to do any real weighing here. I mean, they simply made a finding and did not look at the evidence or make any record of based on the evidence as to a factual basis for the aggravating factors. They simply went beyond that and said, well, because there were 22 blows, that there wasn't any weighing of whether or not, if the person died of the initial blow, that may be a mitigating factor that would require to be weighed against the 22 blows. That was the aggravating side of things. And so the court failed to do any weighing, and therefore the issuance of the hard 40 was contrary to statute. I would also argue that the district court has no jurisdiction to impose an unconstitutional order. And so while I understand the argument of the constitutionality issue simply being a process question or due process argument, if the sentence is in violation of the Constitution, the district court had no jurisdiction to impose that sentence. Jurisdiction stems from both statute and the Constitution, and without compliance with the Constitution.
How do you explain our cases that say that even constitutional issues could not be raised for the first time on appeal? If a constitutional issue is a jurisdictional, then obviously it not only can be raised for the first time on appeal, but the court is to raise it sui sponte. But we haven't treated it that way. We've said you have to preserve constitutional claims as well as any others. So that belies the jurisdictional nature of a constitutional claim, doesn't it?
or the court's line of decisions is wrong, basically. But more importantly,
I'm sorry, go ahead with your answer to Justice Johnson's question, and I'll have one for you.
Thank you, Your Honor. More importantly, that line of cases does allow for an exception for a violation of fundamental rights. And I would argue that the right to jury trial is that. Yes, Your Honor.
That takes us to opposing counsel's point, which is why was this not raised on direct appeal almost 20 years ago?
Well, that's a good question, and I can't really answer that. However, I would argue that regardless of whether it was raised on the fact that it wasn't raised, we can raise it now under the statute because the statute allows us to correct an illegal sentence at any time. Also, the argument of whether or not sentencing is in fact final, counsel suggests that the district court appeal is pointless, that the direct appeal was pointless. And I would suggest that maybe that is correct, and I'd be happy to go back to that point and do the appeal over again after sentencing is in fact complete with the defendant in court when restitution is ordered. If that answers your question.
That's responsive, thank you.
Okay, thank you, Your Honor. Unless the court has any other questions, I would once again ask that the case be remanded to district court.
Any more questions? Thank you, counsel. Thank you both for your arguments this morning. Court will take this matter under advisement.